some reason I got a message that the webinar was no longer available in listening-only modes, but I guess that was incorrect.
Yes, that is incorrect.
Okay.
Okay, shall we get started? This is Elizabeth Gilman from ICWA. Today's webinar will be part of the SERVE program and will be on Public Law 280. And our presenter today is Anne Gilmore from the Administrative Office of the Court, or should I say Judicial Council.
We're the Judicial Council of California now. Hi, everyone. My name is Anne, and I'm an attorney with the Judicial Council of California. And we have there a Tribal Projects Unit that is staffed by my colleague, Vita Castaneda, who many of you may know, who is a social worker. And she and I work together on Indian Child Welfare Act issues. And so today, yes, the discussion is Public Law 280, and more generally, a discussion of the ideas of tribal sovereignty and jurisdiction in Indian country in California, and hopefully an understanding of how those concepts may be important to you in your social work interactions with those tribal communities in California.
Hello?
The sound went out.
Hi.
Okay, hi.
Sorry. So I do want to just say that if you, an important thing to understand about tribal sovereignty is that you may not have heard much about it or have much familiarity with that subject because you won't come across it unless you are dealing with tribal issues. But for tribal communities, it is a very important concept, and they all understand it. So understand that tribal sovereignty comes from the fact that Native American communities were here, living on the land in organized communities with their own forms of government before contact with Europeans. So tribal sovereignty predates the U.S. and the United States Constitution. When tribes talk about exercising their sovereignty, they are talking about exercising their retained inherent rights as Native American peoples, as the First Nations here on the land. So it's not something that they look to the Constitution for. It's not delegated to them by the government, by the federal or state governments. It's something that's inherent to who they are. And the other important thing to understand is that tribes are not parties to the U.S. Constitution. And tribal authority is not derived from or limited by the U.S. Constitution. So tribes have their own governmental institutions. They have their own concepts of justice, but those may not play out in exactly the same way that you would see them in an American system. So, for instance, in California, we now have 20 tribal courts and some courts that are exercising jurisdiction over child welfare matters. And they say that people in the county systems are very reluctant to transfer child welfare cases from state court to tribal court because there's this distrust of a system that they may not understand. So recognize that tribal institutions may be the best ones for their people, even if they don't look like American institutions in every way. And another important concept to keep in mind is that tribes are subject to the will and the power of the federal government, and we'll talk about this later, this idea of them being domestic dependent sovereigns, but they are generally not subject to the power of the states. So as a general matter, state laws and the state government do not have power over Indian tribes or generally over Indian people within Indian countries, so on reservations. when Indian people are in downtown San Francisco, yes, they're subject to the laws that all of us are subject to, just like, German people or, tourists who come are. But when they're in their own territories, there's a different legal framework that governs them. And it's really important to recognize that Indian people, when their sovereignty is infringed upon, when state or county folks go on to tribal lands and act as though there's nothing different about that for Indian people is an infringement of their sovereignty, and they're going to push back on you on that because they know from experience that if they do not protect their sovereignty gets taken away from them. It gets eroded and ignored. So you will often find in your interactions, if you're interacting with tribal social workers or tribal governments, that they are going to be telling you when you are overstepping and pushing into their areas of tribal sovereignty. And they're doing that because that sovereignty has been eroded over time, and it's important to who they are. So don't take it personally. And don't take it personally, and recognize that you might not have thought you were doing anything wrong, but when they're telling you, you can't do that, you don't have the authority, that's an infringement of our sovereignty, that they probably know more about it than you do. So what is sovereignty? For all governments, the concept of sovereignty is defined this way. It is a supreme power, especially over a body politic, a freedom from external control, so autonomy, and that you are the controlling governmental influence in that area. And within the United States, we have three sovereignties that are recognized: the federal government, state governments, and tribal governments. All other governmental entities are subordinate. They get their power delegated to them from another level of government. So, if you're working for the county is just exercising authority that's delegated from the state. They're not a sovereign. Even though they may be bigger and they may have more power than a tribe, they're essentially different because they're exercising delegated authority. So, tribes will demand that respect from you, and they're demanding it because if they don't demand it, their rights go away. So, as I said before, this power of American Indians to govern themselves is grounded in their inherent and retained sovereignty, and it includes the right to make their own laws and be governed by those laws. And those laws may be different from the laws that are controlling in the surrounding county or state. And it is the right of the tribes to have control over their lands and resources and the people who come onto those lands, so onto Indian reservations, or in California, as many of those lands are called, rancherias. Okay. And tribal sovereignty encompasses a whole wide scope of things, but for our purposes here, when we're talking about child welfare, it's important to understand that it includes domestic relations, so family relations, and child welfare. And that this idea of tribal sovereignty, this unique status of tribes, is recognized in the Indian Child Welfare Act, or ICWA, in a variety of ways. And it recognizes, the Indian Child Welfare Act, kind of broadly speaking, recognizes that tribes have a legal interest and a cultural and political interest in their Indian children, and recognizes that Indian children are the tribe's most important resource. And sometimes people, have a little bit of a reaction to that idea of the Indian children being called the tribe's resource, and they have a reaction and think it's like children being treated as property. But from the tribal perspective, what it means is that those Indian children are essential to the continuity of the tribes as a people, as a culture, as a as a vibrant, continuing entity. So we'll talk a little bit later on about some of the assimilation policies and the ways that they try to get rid of Indian communities and assimilate their children. But when we talk about Indian children being a resource, it means that a community cannot survive without children to pass on the language, the culture, the values. And so if Indian children are removed from their communities in high numbers, their communities die and suffer. But the Indian Child Welfare Act also recognizes within it that Indian children's best interests are served by a connection to their tribe and their culture. And when you look at this, think about a child, not just in the moment you're seeing them, but over a child's entire lifetime. What will it mean to be embedded in a culture and know where you came from and feel valued and part of a spiritual and historic connection? Because I think often in child welfare practice, we're dealing with a crisis of a particular moment, and we want to take that child out of crisis and we want to bring them to safety, which of course is an admirable goal. But when you will feel a lot of tension between the Indian Child Welfare Act and some child welfare practice is this central belief that children need stability, and that stability is to be elevated or given more importance than connection. And tribes do not believe that. Tribes believe that children's connections to who they are long-term may be more important than stability at that particular moment in time. And I won't spend too much time on that because it's a really complicated conversation, I think. But I do think that it's important not to think that our knee-jerk ideas about a child's best interest in a non-Indian case necessarily apply without any changes to an Indian child's best interest in a child welfare case, because Congress, when they looked at this and developed the Indian Child Welfare Act, and again when California enacted its own version of the Indian Child Welfare Act, they recognized the importance of an Indian child remaining connected to their tribe. So tribes are sovereign, but they have a unique sovereignty where they are recognized as something called domestic dependent sovereigns. So they are subject to the will of the federal government. But they do have civil and criminal jurisdiction over their territory, over their tribal members, over non-member Indians who come onto their tribal lands, but not necessarily over non-Indians. For non-Indians, tribes can exercise civil jurisdiction in some ways, but limited criminal jurisdiction. There've recently been some extensions of criminal jurisdiction in the context of Violence Against Women Act, because there's a crisis in Indian country because they don't have any power over non-Indians who come into their lands. There's a crisis of abuse against Native American women. But they have no power of external sovereignty, which means they can't, go out and make treaties with foreign countries, and they are subject to the plenary authority of Congress, which means that if Congress wants to, it can take away tribal powers, and it has done that in a number of cases. So the congressional authority, the federal authority over Indian people is found in the U.S. Constitution. It's grounded in the Commerce Clause here, which says that Congress shall have power to regulate commerce with foreign nations and among the several states and the Indian tribes. So all of that leads us to kind of the to a starting point for jurisdiction in Indian country. It should be the one before that.
I know, I'm trying to get it.
Okay. So the starting point for jurisdiction in Indian country is, I think, as I said before, that tribes have plenary and generally exclusive jurisdiction until something changes over their members and their territory, but they don't have criminal jurisdiction over non-Indians, with the one exception of the Bawa. And the other important point is that, as a general matter, the state does not have authority over Indians in Indian country. And when I say Indian country, that's a legal term, and it means all the Indian reservation lands. So in many states in the United States, the county and the states do not exercise child welfare jurisdiction over Indian lands. If you have Indian families living on the reservation, that's outside the jurisdiction of the state or the county. In California, that scheme changed in 1953 when the federal government enacted Public Law 280, which you'll often hear referred to as PL 280. And what that statute did was to grant California criminal jurisdiction in Indian country. So California can now go and prosecute any crimes that occur in Indian country, even if it's Indian people committing those crimes. And it grants limited civil jurisdiction to hear matters concerning that arise on the reservation. And PL 280 is what's pointed to ground jurisdiction in California over child welfare matters, even if they occur on the reservation. But, you know, there's some tribal advocates who do not agree that PL 280 granted jurisdiction over child welfare on reservation. But this is the law we point to as giving that jurisdiction. And it's really important to recognize that PL 280 was passed without any consultation with Indian people. Indian people did not consent to having state jurisdiction extended onto their tribal lands, and many of them felt like, and still do feel like, that was an improper infringement of their sovereignty. But what did PL 280 do? Well, it did extend federal or state authority, but it did not terminate tribes in California. It did not take away any authority that tribes had over their lands. It meant that the tribes and the state of California now exercise concurrent jurisdiction in those areas. So tribes can also have jurisdiction over their child welfare matters on reservation lands, and they share that with the state and counties. The trust status of Indian lands was maintained. Nothing changed there. And it didn't really change the legal obligation of the federal government to continue to provide services to tribes. But in practice, in California, the federal government withdrew most of the supports that it had previously provided to tribes, and instead expected the state and the counties to pick up those services. And it did not authorize the state to take any jurisdiction over tribes themselves, just over individual people in Indian lands. So that's sort of the jurisdictional landscape, but we also want to understand the particular histories of California Indian tribes when we are working with California Indian people in child welfare matters, and to understand how it can make ICWA compliance in California particularly challenging. So from a California or from a historical point of view, the historical archaeological evidence confirms that there were Indians in California, or Native American people in California, dating back to at least 8,000 BC. So that's the scientist's viewpoint. From a tribal viewpoint, each tribe has their own creation story that explains their tribal origins and ties their origins to the land and to the territory that they live in. And it's really important to understand that Indian people, for the most part, are land-based, so that their cultures and their spiritual practices are tied to a particular land base, and they have a relationship with that land base rather than feeling that they have ownership of it. And that's a really big distinction. And there were historically at least 35 distinct languages in California, and over 500 bands and 105 tribal groupings, and occupied the lands throughout what we now know of as California. And when you look at this map is, probably a kind of crude delineation, but it is, gives you an idea of the occupation of California prior to contact. And you can see the groups throughout California, and also see the way in which to the north for Oregon, or to the east with Arizona and Nevada, or to the south with Mexico, that those territories just stop abruptly at the California border. But historically, those people's territories would have, and the people would have ranged into Mexico or Arizona or Nevada or Oregon, that for the Native American population, those borders that we think of as being so important are arbitrary for their identification. And for Indian Child Welfare Act purposes, it can be really important to recognize that, because there may be tribal groupings where the territory traverses the international border between Canada and the United States. And people will have family and connections on both sides of the border. And that relationship can create a legal relationship for people who might have been born in Canada and think of themselves only as Canadians. They still might have a right to membership in a federally recognized United States tribe. So it's important to get away from our thoughts of what's important in territory and recognize that there's a tribal perspective that is different and that has both cultural and legal meaning in what we're working on today. So some key dates I call it California Indian history, but it's really the history of contact. The first European contact is estimated to be around 1542. But the most significant event, the first significant event of contact, was when Sir Francis Drake spent 5 years in Point Reyes in 1579, and 5 weeks, spent 5 weeks, 5 weeks in Point Reyes in 1579, and based on that claimed the entire territory of California for the crown. And another important thing 200 years later, we're skipping 200 years, and to understand that contact had devastating impacts on the Native American populations in between that, because they were exposed to diseases that they didn't have immunities to, and that devastated the Native American population. But in California, the first missions were established in 1769, and the missions were founded by the Spanish with the express goal of civilizing, and when you hear civilizing, read assimilating Native American people. And at that time, the Indian population was estimated to be 310,000. Play button over in the corner.
Hang on a moment.
Is that loud enough?
300,000 people lived in the diverse environments of California. They spoke 80 languages, worked, worshipped, and raised children on lands occupied by their ancestors since before the dawn of European civilization. Many California nations had evolved into highly structured societies. Among them, one of the largest was the Chumash, living on the coastal islands and along the coast in the area of present-day Santa Barbara. Large Chumash towns supported a professional class of astrologers, priests, government leaders, and healers. Workers belonged to centuries-old craft guilds of basket and canoe makers. Workers also manufactured the flat shell beads that were the currency of the region. Production and control of the money supply placed the Chumash nation at the center of the Southern California economy. In the late 18th century, this complex world of the ancient Chumash and their coastal neighbors would be changed forever. In 1772, Spanish missionaries, led by Father Junipero Serra, arrived in Chumash territory.
Believe me, when I saw their general behavior, their pleasing ways and engaging manners, my heart was broken to think that they were still deprived of the light of the Holy Gospel. Father Junipero Serra, Spanish missionary.
Ignoring the beauty and complexity of Chumash society, the Spanish set out to convert them to Christianity by whatever means necessary.
I and two of my relatives went down to the beach to catch clams. We saw two men on horseback coming rapidly towards us. My relatives were afraid. They fled with all speed. It was too late. They overtook me and lassoed and dragged me for a long distance. Their horses running. When we arrived at the mission, they locked me in a room for a week. The father told me that he would make me a Christian. One day they threw water on my head and gave me salt to eat. And with this, the interpreter told me that now I was Christian, and that I was called Jesus.
The building up of the mission into a coercive labor force didn't happen overnight. It was a gradual thing, but eventually they began forcing Indians to remove from their free way of life in their home villages and to be reduced to one central mission site to be controlled. Once a family was taken in to the missions, the missionaries separated children from their parents. All the little boys and the little girls at the age of 6 were locked up in children's barracks. So it was work, religion, and work all day long. Highly structured, highly supervised.
Indian people were put to work tanning, blacksmithing, and caring for the mission herds. They made candles, bricks, tiles, shoes, saddles, and soap. Labor was strictly enforced under the discipline of the lash.
And thus I existed, till I found a way to escape. But I was tracked, and they caught me like a fox. They lashed me until I lost consciousness. For several days I could not raise myself from the floor where they had laid me. And I still have on my shoulders the marks of the lashes. Hanitil Kumiai.
For over 50 years, the mission system, backed by Spanish arms, exerted control over the California coast, crushing every revolt. Inside the missions, disease and harsh living conditions contributed to a genocidal death rate.
The average life of a mission Indian was about less than 12 years. For children, it was less than 6 years. And so there was a constant need to feed this beast with laborers. one of the sad legacies of the missions of California is that when people go to them today, they don't even think about Indians. They say the Padres built the missions. That's nonsense. The California Indians built the missions.
At the Santa Barbara Mission alone, over 4,000 Chumash names filled the burial registry. Their bodies discarded in large pits near the church. In 1821, control of California transferred to Mexico after it gained its independence from Spain. The Mexican government secularized the missions. Indian people were free to leave. But 50 years had completely transformed their world. Old villages were gone. In their places were large Mexican estates. Even the mission lands they had worked and lived on became parts of vast private ranches.
To stand by and watch these men take over the missions which we have built, the herds we have tended, to be exposed incessantly together with our families to the worst possible treatment and even death itself, is a tragedy. Mission San Luis Rey, neophyte.
Homeless and left with few choices for survival, mission Indians were forced to exchange one master for another, becoming peasant workers on the rancherias.
Many of the rich men of the country had from 20 to 60 Indian servants whom they dressed and fed. Our friendly Indians tilled our soil, pastured our cattle, cut our lumber, built our houses, made tiles for our homes, ground our grain, slaughtered our cattle, dressed their hides for market. While the Indian women made excellent servants, took good care of our children, made every one of our meals. Salvador Vallejo, Mexican landowner.
So what we're talking about here, I think if you just click on the next slide, it should go. So what we're talking about here are the major events that contributed to the destruction of California Indian family structures and are some of the roots of the sort of historical trauma which devastates Indian communities and which you will find today when you're dealing with Native American families. So they were talking there about the mission systems and the life under Spanish and Mexican rule. But then California passed to the United States by a treaty in 1848, which ended the Mexican-American War, the Treaty of Guadalupe Hidalgo. The territory of Arizona, California, New Mexico, Texas, Colorado, Nevada, and Utah was ceded from Mexico to the United States. And what's kind of important for our discussion of California Indian history, and what doesn't, I think, make it into popular knowledge, is that under the terms of that treaty, Indian people were to have rights, property rights, over the territories that they had occupied. And those rights were never recognized by California, and we'll talk about that a little bit later on, I think. Okay. The next historical event in California that was devastating for tribal communities was the gold rush, which started right around the time that California transferred to the United States and became a state.
All right, put it down.
It's a little play.
We'll play that and
It's over here.
That's what I was doing, yeah, okay.
In 1848, after the Mexican-American War, California passed from Mexican to American hands. Soon after, gold was discovered in the north, bringing a rush of miners onto the lands of interior nations who had been out of the reach of coastal missions and Mexican ranches.
The majority of tribes are kept in constant fear on account of the indiscriminate and inhuman massacre of their people. They have become alarmed by the increased flood of immigration, much spread over their country. It is just incomprehensible to them. Adam Johnson, Indian Agent.
Miners came into Indian communities looking for women. Vigilante parties opened fire on men, women, and children, wiping out entire villages. It was open season on Indian people, derisively referred to as diggers.
The Humboldt Times, Eureka, April 11. Headline, Good Haul of Diggers. 1 white man killed, 38 bucks killed, 40 squaws and children taken.
January 17th, headline, Good Haul of Diggers. Band exterminated.
In the 1850s, while the American nation was on the verge of civil war over the issue of slavery, demand for agricultural labor in California was so high that the state legislature passed an act legalizing Indian slavery.
A company of United States troops, attended by a considerable volunteer force, has been pursuing the poor creatures from one retreat to another. The kidnappers follow at the heels of the soldiers to seize the children when their parents are murdered and sell them to the best advantage. W.P. Dole, Indian Agent.
Only 30,000 native Californians survived the gold rush. 10% of what had been the most densely populated Indian area north of Mexico.
Upon my last visit to Ventura, I saw the last of the Ventura Indians. They were living in a tiny hut east of the mouth of the river. One of the old men told me they were very glad that I was not ashamed to talk the Indian language. They told me to continue in the use of it and keep the beliefs. If I did so, I would live a long time. Fernando Librado, Chumash.
Fernando Librado lived to be 111 years old.
I once went over to Dona Siana's house. I wanted to learn the swordfish dance. After the meal, I asked her to teach me the old dances, saying, "For you are the only ones left who know the old dances." Dona Siana began to cry, and I left saying nothing more. Fernando Librado, Chumash.
For thousands.
So if anybody's interested, those clips are from a resource called 500 Nations, and it's actually available on YouTube if you want to watch more of it. They have more about California and more things generally about history of Native Americans in the United States. So there was a little discussion there about the 1850 California laws, and I have some links at the end to some resources that might be of interest. But so those laws, which, you know, ironically speaking, as laws are always titled, they were called the Laws for the Protection of Native Americans, but they allowed for indentured servitude of Indian people. So in this state, we have papers showing judges allowing children as young as 5 and people as old as 50 being forced into slavery, basically, working for white people. It was illegal to sell alcohol to Indians. If anything was done to an Indian, assaulted or raped or anything like that, they could not testify in court against a white person as to any crime. And the government was actively seeking to exterminate Native Americans, so there were bounties offered on Indian people. So if a white man could go out and collect the scalp or the head or body parts of Indians and bring them to the government for money. So you can imagine how incredibly destructive that is to a society, to a community. You no longer feel safe identifying as who you are. So many Native American people would say they were Spanish instead of saying they were Indian, because it was just too dangerous to be Indian. And then in California, I talked earlier about how under Mexican law and under the Treaty of Guadalupe Hidalgo, Indian land rights were to be protected and respected by the United States. And in 1851 and 1852, the federal government went out and negotiated 18 treaties with California Indians that would have reserved for the California Indians about a third of the land in California. But those treaties were never ratified because gold was discovered and the state of California objected to these treaties. And so they were basically hidden for 50 years until somebody discovered them on a shelf. But Indians thought that they had treaties. They thought that they had entered into agreements to protect their lands. And so they moved on to the reservation lands. But nevertheless, they were forced off of those later. They lost their lands. There were forcible removals. There were degradation of their hunting and fishing territories. And each tribe in California will be able to tell you their own history of their own trail of tears, their own destruction of their own community. And California's first governor in 1851, the first governor, Peter Burnett, declared that a war of extermination will continue to be waged between the races until the Indian race becomes extinct, must be expected. So that was official government policy and their actions around that. So when we talk about Native American people having a distrust of government, that distrust is well-founded. It's grounded in a lot of real experience that they have had. The next important era, and these are just general eras to understand, but as I said before, each tribe has their own particular history, was the boarding school era. The first boarding schools, Indian boarding schools, were opened in the 1860s. And Indian children were forcibly removed from their families and placed into boarding schools where they could not speak their languages, they could not practice their religions. And the goal of these schools was to kill the Indian and save the child. The goal was to remove Indian children so that they could be assimilated and they would no longer identify with their Indian cultures. Their hair was cut. They were forbidden to speak their own tribal languages, and sometimes children were away from their communities and their families from 5 years old until they were 18, and they would come home to their communities or come back to their communities, and they wouldn't be able to speak the language. They wouldn't know the traditions. They would essentially have no place in those communities because they had not learned that place. And so that is the Native American experience of when the government takes your children away. That is what happens. And whether that's done through a boarding school or child welfare or any other system, for Native American communities, the removal of their children was a part of assimilation. And if you look at the definition of genocide, the forcible removal of a people's children is a genocidal practice, and that was what was practiced against Native Americans through the boarding schools. The next thing was the Indian Adoption Project. It was less large, but even after the Indian boarding schools were shut down, in the 1950s there was a concerted effort by the Bureau of Indian Affairs in concert with the American Adoption Association. I think that's what it's called, and they have since apologized to Native Americans for this, but to target Native American children for removal from their families based on things like poverty or a mother being unwed, and to place those children for adoption in non-Indian homes. And the child welfare system was also used as a way of removing Indian children. So before Congress passed the Indian Child Welfare Act in 1978, they had testimony before them and studies before them that showed that about 25 to 35% of all Indian children were removed from their families and communities and placed in non-Indian homes or institutions for raising. And for Indian people, this was just as destructive to their communities as was the boarding school project or any of the other things we've talked about. And that was all done by social workers who thought they were doing the right thing for those individual children, because they thought those individual children would be better off in a better, moral situation or a better financial situation. And by far, most of those removals were for neglect and not for abuse. And what the Indian Child Welfare Act reflects is that having a different family structure, having a different way of raising children that recognizes that children belong to the community and not just to a nuclear family, that is not a reason to remove a child. So we have to have a sensitivity to the cultural aspects of child raising within the Indian communities. So some things to understand about California's tribal communities today that makes it a challenge for county workers to fully comply with the Indian Child Welfare Act. Today in California, we have 110 federally recognized Indian tribes. That's about 20% of the tribes in the United States. Alaska has a lot more. But in California, we have a lot of very small tribal groupings, and there's a lot of interrelatedness between these groupings, and so it makes it very complicated. We also have a large unrecognized California Indian population, and what that means, and we have 78 groups that are petitioning for recognition, and what that means is that those families, those individuals, they trace their ancestry to historical California Indian groupings, but their particular community is not recognized by the federal government as being a sovereign Indian tribe. So it's really important to recognize and be sensitive to the fact that people have their cultural and ethnic and individual identity as a Native American, as an Indian, and that is real, whether or not they can prove membership in a federally recognized tribe. Membership in a federally recognized tribe is the trigger for ICWA, for the Indian Child Welfare Act, and the legal obligations that flow from that, but it's not exactly the same as their individual identity. So there are 720,000 California citizens. I think that number has actually grown now, but at the last census in 2010, who identify as American Indian or Alaska Native, and they are throughout California. And that represents 12% of all American Indians and Alaska Natives in the United States. So it's important for us to realize that we have to get it right here in California, because what we do matters. We have tribes as small as 5 members, and then the Yurok tribe in Northern California is the largest California tribe with around 6,000 members. And the other important historical event to keep in mind that affects us in California is the relocation period in the 1950s and 60s. This was another assimilation of policy of the federal government, where they went to Indian peoples in, living on reservations in Oklahoma and Arizona and elsewhere, and they wanted to lure them away from their tribal communities, to break up those tribal communities by saying to people, if you move to Los Angeles or California or, San Francisco or Chicago was another, or New York, those are other relocation centers. You go out there, there are more opportunities for you. We will provide you with housing. We will provide you with, this and that other thing. And of course, when they moved away from their communities, the supports that they were expecting were not there. They were living essentially in ghettos, and they were disconnected from their tribal communities, which is what was intended. And we have the legacy of that now in California, where we have very large urban Indian populations in the Bay Area and in Los Angeles, and now generations who may well be Cherokee, Navajo, Chickasaw, any of those other tribal affiliations, but they may not have had a lot of connection with their tribe in the last generation or so. But I would urge you to think that that doesn't mean that that tribal connection cannot be very beneficial to an Indian child, even though they might not have a connection with the tribe right now. The tribal history and culture and sense of being and sense of belonging may well be very beneficial to them. But it requires some effort on our part. So this next map shows you the federally recognized tribes in California today. And if we were to spend some time analyzing this map, you would see that Indian tribes are concentrated in areas that didn't have a lot of value. So you don't have basically any Indian tribes along the coast from San Francisco to Los Angeles. Not because Indian people didn't live there. It's because those lands were too valuable for the federal government to set aside reservations for them. People had already claimed those lands. And it's not that Indian people don't still live there in their traditional territories. It's just that they're not recognized as Indian tribes. And what makes this very challenging as well for our purposes is if you're to compare these two maps, the map that we saw earlier that had the historical tribal identities, with this map, which has the way the federal government recognizes it, so it has the federally recognized tribal names, you'll see that the federally recognized tribal name doesn't always match up or have any relationship to people's historical tribal identity. So people will tell you, my grandma is Pomo, or I am Pomo, and that is hard for you to translate into a list of federally recognized tribes that you need to notice, because the Pomo tribes up here in, we see them in just north of San Francisco in Mendocino County. They have names like Laytonville Rancheria, Sherwood Valley Rancheria, Pinoleville Rancheria. Those are Pomo people, but it's hard for us to translate between the federal recognition and how people self-identify. So what is federal recognition? It means that a particular entity, a particular group of tribal people is on the list of tribal entities published by the federal government. They publish it every year in the Federal Register, and there's a list entitled to services from the Bureau of Indian Affairs because of their status as Native American. And there's a whole bunch of hoops that tribal groups have to go through, and they have to provide evidence if they want to get added to that list. And it recognizes the sovereign government-to-government relationship between the tribe and the United States. And so that's kind of the ICWA trigger, is that sovereign government-to-government relationship. But that list was only established in 1978, and the criteria to get on that list was established by the federal government, not in any consultation with tribes. And it did not recognize California Indians' unique history. So a lot of tribal entities were left off of that list, and so we have a lot of unrecognized tribes in California. And the other wrinkle in California is that we have a lot of tribes that were recognized as tribes, federally recognized tribes at one point, but then were terminated during assimilation period, so that the federal government said, okay, you have these lands, we're going to distribute these lands to you individually and give you some money, and then we're going to cut you off as Indians, and we're going to wash our hands of you. Some of those tribes have been restored, but those are also Indian people, and they're not necessarily recognized. So it's important for us as social workers to know that federal recognition is not the same as an individual Indian identity. And even if someone does not is not qualified for membership in a federally recognized tribe, in California there's a special definition of California Indian. And a California Indian is a person with Indian blood who can trace their ancestry to somebody who appears on various rolls and censuses of Indians that were taken by the federal government and living in California in 1852. So that can be a lot of people who are not members of federally recognized tribes. And those people are, as individuals, entitled to health benefits and other services from the Indian Health Services. So even if somebody is not a member of a federally recognized tribe, there may be many benefits for that family to be connected to their Indian identity. And it's also important to recognize that many groups in California are seeking federal recognition, and that changes over time. There are groups that have been recognized, over the past few years, and new tribes are added over time. So just because you've heard of a tribal name, sometime in, 5 years ago, and that tribe was not federally recognized, does not mean that when you hear that again today, when a family says, I'm from the Wilton Rancheria, that's one of the more recently recognized tribes in California, that tribe is federally recognized today, so ICWA does apply to them. So how does that all relate to the Indian Child Welfare Act itself? So as I said before, it recognizes, it's a federal law, it sets minimum federal standards for all of us when we are removing Indian children from their families. And it recognizes this relationship between a tribe and the children who are members of that tribe. And it recognizes the tribe as a party with a legal interest in these proceedings involving their Indian children. So think of them in some ways like a non-offending parent, a non-custodial, non-offending parent. We make an effort to seek those people out because we recognize that they can be very beneficial to an Indian child or to a child. And think of the tribe the same way, because Indian children have an interest in and a right to their tribal culture and identity. And that's what we're doing when we connect them with their tribes by following the minimum federal standards set out in the federal law, and sometimes even going above those minimum standards. And the Indian Child Welfare Act itself recognizes and affirms tribal sovereignty over their children and confirms a general preference for tribal jurisdiction over Indian child welfare cases involving those children. So this is what the law actually says. It says that if the tribes have exclusive jurisdiction or where there is concurrent jurisdiction, as there is in California, that there's a preference to transfer those cases to tribal court when the tribe asks for a transfer. So moving on to the next slide, I think. This is just me. I've recognized some ways what are the implications of this for your social work practice. And I think that understanding that the roots of a family's trauma may be very different than the roots of another family's trauma is important. And the solutions to that family's trauma may be different. And in the Indian Child Welfare Act, those solutions are identified as active efforts, which means that you should be looking for culturally appropriate services and drawing in the child's tribe. And that the family's Indian identity should be considered in a number of ways, in considering where that child should be placed and what services are appropriate for that family. And particularly with respect to placement and case planning and all of those things, that a child's tribe and extended family must be considered. Available resources may be different for these families and these children. So you would look for culturally relevant resources through the tribe and Indian health services and these other places. And then there are special Indian Child Welfare Act requirements from the beginning to the end of a case, beginning with inquiry in all of our child welfare cases. You have to ask about Native American ancestry and then ensure that the tribe gets timely and meaningful notice. Provide the parents and child with active efforts and consider the placement preferences and other standards. And then if you want further resources, we have some resources. The first thing is our website, where there were a bunch of handouts for this webinar, and most of them are available on our website, that tribal program. And there's also, I've given you a direct link to a National Park Service timeline of Native American history in California, because I think it's really interesting and important. And if you're working in a particular community, you may want to know a little bit more about their history. And then I've also given you a link to where you can find those early California laws and policies related to Native Americans. And now I'm happy to take any questions that anybody might have. Or even not questions, just if you want to talk about any of this and your own experiences with it.
Any thoughts from the viewers of the PowerPoint who have been listening along with us? Well, I'd like to say there were several things in this presentation that I was not aware of, and I was very happy to learn more of the historical facts, which became increasingly appalling as we went along. Certainly is a pattern in practice here.
Yeah.
And I was astonished that it had continued for, 150 years, and it's continuing even now, apparently.
Well, it is, and I think we continue it without knowing it when we don't consider the historical context. What I have observed doing this work is that people believing that they're doing the best thing for the particular child before them in the specific circumstances that they find themselves in tend to just feel like they can push all of that other stuff aside and say, okay, well, that's history, or this, or that's that, and not see how it's relevant to the particular case that they find themselves in. And so I think that's the biggest struggle I see in making this meaningful in the child welfare practice.
Anne, can you hear me?
Yes.
This is Kathy Ralph at UC Berkeley, and I wanted to thank you also for the great presentation. one of our graduates is your coworker, Vita
Yes.
Castaneda. And so
Yeah.
Vita has shown class after class of mine some portions of what you just went through. So really appreciate the depth of information and all the resources attached to it and all. And so it was even more meaningful. And I'm a former child welfare worker who was originally the ICWA contact person in Alameda County when it first passed.
Oh, wow.
So I've worked with a lot of cases. Is there still some opportunity for knowledgeable child welfare workers to persuade their judges to act in accord with the spirit of ICWA if there's not a particular federally recognized tribal link for particular children or families?
Sure. There is provision to under the Welfare and Institutions Code, I believe, for a judge to have discretion to allow a non-federally recognized tribal group to participate in the actual proceedings. Mm-hmm. But I think that it's, I don't think that any judge would object to a social worker reaching out for resources, culturally appropriate resources for a family. So yes,
well, I'm just thinking in terms of from the starting point of 1979. When we had our first identified ICWA case in Alameda County, so just after the passage of the law, there were so few federally recognized tribes, and yet, so many families that were coming to our attention that were connected to a tribe that wasn't yet federally recognized, is now, that I was able to persuade our judge usually to act in that spirit, but I didn't know if that was not done in other counties, like frowned upon by their judges, et cetera, and you might have a better overview of that from the Judicial Council.
So my sense is that social workers have a lot of influence in shaping the case for the judge. That's I know that judges, will question social workers at times and all this. But my experience is that the social workers report and the way they frame the family's strengths and weaknesses is very powerful and very influential. And so I think if a social worker were to put in context the family's self-identification and what that means for the family, and then do a little bit of work in figuring out what resources are available for that family, I think a judge would be persuaded by that.
Good to hear. Thank you.
But that is, that's different than the legal requirements of the Act. So
right.
There is a big pushback right now on having to send ICWA notices far and wide.
Yeah.
And we have a case pending right now before the California Supreme Court, which will really impact a lot of these things, because in California, as I mentioned, with the relocation, we have a lot of people now who are maybe several generations removed from their from a lot of contact with their tribal culture. And the Indian Child Welfare Act has a specific definition of Indian child, and it says an Indian child is under 18, they're unmarried, and the child is a member or eligible for membership in a tribe, and the biological child of a member. So if a child is a member of a tribe, then ICWA applies to them automatically. If they're just eligible for membership in a tribe, in California, we had always said treat them as an Indian child. And now this case is saying, well, if they're not actually a member and their parent is not a member, then we don't have to do anything for them.
Wow.
And that's very disturbing, I find, in California. But
Yeah.
that's the case that's pending before the California Supreme Court. And actually, oral arguments are on Tuesday.
Right. So I'm training students who are going off into child welfare practice, and by having been immersed in a very good training myself by Marilyn St. Germain at that time, back in the day, just understanding this whole historical perspective that you just gave was instrumental in my saying, to err on the side of membership rather than non-membership, or applicability of ICWA rather than not. And so I'm also disturbed, but I'm trying to get a crew of budding social workers out there who will get your point and hopefully never take it to that level. But I hear from them about how things are handled in the counties where they're doing internships, and some of that is also very disturbing. About ask them once, if they say it no to the ER worker about their Indian ancestry, then that's it forever. We don't have to keep on asking, and that just seems so destructive.
The affirmative and continuing duty to inquire. Well, that's very interesting. I'd be interested in talking with you about particular county practices. Maybe not right here on the phone as we're in our webinar, but that would be interesting. But I think my own sense is that even if people accept as a general principle the values of the Indian Child Welfare Act, they still chafe at complying with the requirements of the law, in particular, as you said, the duty of inquiry, which can be kind of onerous, and the duty of notice, and then also having an extra party at the table that may express an opinion that is contrary to what the social worker wants to do. That, so even if somebody were to accept the general principle that there's a value to keep Indian children connected to their tribes and culture and all of that, they still may not like to have the extra burden of all the ICWA requirements, and they may not see the value of that. And that's hard to get around. Because, if the social workers are not doing the inquiry at the front end, and they're not sending notices, and they don't see the value of that, and I kind of get it, because some social workers will tell you, we send out hundreds of these, and the children are never eligible, or the tribe never responds, and I sort of get that. But then the problem is that all of these things come up at the back end. So they come up. You'll find at, when you're at the 2-6 hearing, which is when, at least previously, attorneys used to turn their attention to, is there an ICWA flaw in here? And that's when you find out that inquiry wasn't done and notices weren't proper. And then, in fact, this is an Indian child, and we should have been doing things differently all along. And the tribe has been deprived of any meaningful right to participate in the case as it went through. And then we set up this situation where it does seem like the interests of the tribe are, interfering with what people want to do and think is in the best interest of the child. And so we have to do, I think, careful ICWA compliance work at the front end if what we really think is we want to look out for the best interests of each child.
Thank you.
Thank you, Catherine. I have a follow-up question to that. Is there an effort to define active efforts in a very standardized manner such that that can be easily understood and the standard more readily obeyed?
Yeah, I think that's a really good point. There were some new guidelines issued by the federal government. When they issued the Indian Child Welfare Act or enacted it in 1978. In 1979, they issued some guidelines for state courts to follow, and those were not binding, and they weren't super helpful. But they did issue last year in February some new guidelines, which contained kind of a detailed definition of active efforts and gave some examples. And then there are proposed federal regulations for the first time. Those would be binding on the state courts that also have a definition of active effort. And interestingly for California, those definitions of active effort say that they have to be more than reasonable efforts, because in California we didn't believe that. And so yes, that's out there, and we're actually applying for a grant, and we're hoping that out of that will come some ability to bring child welfare workers and tribes together to kind of agree on standards. So yes, there's guidance in the guidelines. There will be more guidance in the federal regulations when they're finalized, and then we're hoping to try and implement that in California in a collaborative way.
Thank you very much. Sounds like it's an important effort.
Yeah, it would be nice if, because, what I often hear is this frustration on that people don't want to comply with the act, and in some ways I think they don't. But then there are other areas where I think there's just differences of opinion about what active efforts really requires, and things like that. So.
Does anyone else have a question to ask our presenter?
And you have my contact information on that last slide. And Vida, who Kathy mentioned, Vida and I are available as resources if you have questions about ICWA that come up in your practice. So you don't have to think of every question right now if it doesn't come to mind.
I'd like to let everyone know that Anne shared a large number of materials with us, which I believe Michelle Rainier has sent to the project coordinators. If anyone does not have access to those and would like them, please let me know, and I will be very happy to send them to you.
Thanks, Elizabeth, for bringing this.
Well, I think we should really thank Anne. You're very welcome.
You're welcome.
Extremely impressed. This is the long form, and it was really good to have the long form because it was in considerably greater depth than the information that we usually have, and I really appreciate it.
Well, this wasn't really the long form. The long form could go on for months.
Yeah, for my own self, this is all I can manage to absorb in one day. Thank you so very much. This is
you're welcome.
Thanks, Anne.
Opportunity. Bye.
Thank you all. Bye.
Bye.
Thank you.
Touch.